What started as courtroom humiliation turned into the most shocking constitutional argument the Supreme Court had seen in decades. Before we dive in, let us know where you're watching from today. And if you like this story, don't forget to subscribe. Courtroom 3 of the United States Supreme Court was silent. Too silent. The kind of silence that builds before something irreversible happens. At the lectern stood Arnold Schwarzenegger, a man whose broad frame and stoic presence had once dominated Hollywood action films and, later, California's political stage. Yet here, against the cold marble pillars and the austere stare of the 9 justices, even someone of his stature seemed like an outsider. Chief Justice John Roberts adjusted his glasses, his voice cutting through the silence like a scalpel. "Mr. Schwarzenegger, I appreciate your interest in this proceeding," he said, pausing just long enough for the condescension to settle. "But this court is not a stage for political legacies or cinematic flair. Constitutional interpretation demands more than charisma." A few muffled chuckles rose from the gallery. Law clerks exchanged glances, the kind that say, "I knew this was coming." A corporate litigator in the second row leaned toward his colleague and whispered, "They let him argue? This isn't a town hall." Another replied, "He'll last 5 minutes." But Arnold didn't flinch. He stood exactly as he had for decades, not as an actor, not as a governor, but as a man who had never let skepticism define him. His tailored gray suit sat perfectly across his shoulders. He carried no entourage, no media team, just a worn leather briefcase and a quiet confidence that rarely needed defending. He glanced once at the bench, meeting the eyes of the Chief Justice, not in defiance, but with the calm of a man who had already survived 1,000 interrogations, on camera, on the campaign trail, in life. 3 months earlier, when his name had appeared on the amicus docket in Henderson v. Department of Justice, the legal world had collectively arched its eyebrows. The case itself was already a powder keg about the government's ability to seize properties in low-income neighborhoods under civil forfeiture laws. But a real buzz came when it was revealed that Arnold Schwarzenegger, former governor of California, had submitted a 38-page amicus brief challenging the very doctrine that had stood nearly unchallenged for decades. Most assumed it was a symbolic gesture, an attempt to leverage his fame for policy influence. Few knew that for the last 7 years, Arnold had been quietly studying law through a remote program, followed by an honorary fellowship at UCLA's law school, where he spent nights poring over constitutional texts and early American legal archives. Now, standing before the most powerful legal minds in the country, he prepared to deliver 10 minutes of oral argument, a rare privilege granted by the court, and one many believed would be more spectacle than substance. The expectation in the room was clear, that this would be a short, perhaps even embarrassing performance by a man unprepared for the rigor of the highest bench. Justice Sonia Sotomayor tilted her head slightly, observing him with what looked like measured curiosity. Justice Clarence Thomas remained unreadable. Justice Kagan scribbled something on a notepad but didn't look up. Only Roberts maintained eye contact, his posture rigid, his tone flat. "You may proceed, Mr. Schwarzenegger," he said. Arnold opened his briefcase, slowly, deliberately. Inside was a copy of the Constitution, annotated by hand, worn at the edges. He placed it gently on the podium, then unfolded a single sheet of notes. He did not fumble. He did not glance nervously at the bench. And when he finally spoke, his voice was quieter than anyone expected, low, deliberate, with the kind of weight that didn't need volume to carry power. "Mr. Chief Justice," he began, "and may it please the court, the Constitution is not a document of government convenience. It is a covenant between the governed and those who serve them. Civil forfeiture, as it currently stands, threatens that covenant." He paused, not just through its outcomes, but through its logic. And in Henderson, that logic fails. He didn't look at notes again. He didn't quote cases yet. What he delivered in the first minute was not legal jargon, but a philosophical stake in the ground. It took less than 60 seconds for Chief Justice Roberts to interrupt. "Mr. Schwarzenegger," he said, his tone more direct now, "your brief, while well-intentioned, seemed to overlook 2 centuries of settled precedent. This court has affirmed the government's forfeiture authority repeatedly, often in cases involving threats to public safety. What precisely gives you confidence that your interpretation holds water in light of that?" A few heads in the gallery turned. This was the expected moment. the unraveling. But Arnold remained steady. "Chief Justice," he said, his voice unwavering. "Precedent can preserve wisdom, but it can also fossilize error. I believe the court's reliance on certain historical doctrines, particularly those arising from admiralty and piracy cases, has drifted from the constitutional principles the founders intended. And in this instance, I am prepared to show how." He reached back into his briefcase and removed a folded document. It was a copy of a rarely cited 1795 state court ruling, marked in faded ink. He held it up briefly before laying it beside the Constitution. This was written before the Palmyra decision, before Bennis versus Michigan, before this body made forfeiture the exception rather than the rule. It speaks not in theory, but in context, and that context matters. Roberts didn't respond immediately. His eyes narrowed slightly as if reassessing the moment. A ripple of unease passed through the room. Not because Arnold had said something dramatic, but because he had said it with unexpected precision. In the back row, a legal blogger typed quickly, "He's not just holding his own, he's recalibrating the room." Somewhere, a clerk leaned forward and whispered to another, "This isn't just a guest appearance. This might be a doctrinal shift." The air grew heavier, not with skepticism, but with curiosity. Arnold continued, slowly building toward what would soon become the foundation of a legal argument that neither the court nor the country was ready for. But in that moment, in that precise pause between question and rebuttal, the dynamic had already begun to change, not with noise, but with silence, filled by the weight of a man who had come not to perform. 3 days before the oral argument, a low-profile article appeared in the legal section of the Los Angeles Daily Journal. Its headline was simple: "Former Governor Submits Unorthodox Brief in Supreme Court Forfeiture Case." Most skipped over it. Those who clicked found a dense analysis of the 38-page amicus brief filed in Henderson v. Department of Justice, a civil forfeiture case that had already drawn national attention. The author of the brief was listed as Arnold Schwarzenegger, which some assumed was a publicity stunt. But buried halfway through the article was a line that changed everything. Sources confirmed Schwarzenegger has completed a graduate legal fellowship at UCLA School of Law, focusing on constitutional property rights and historical takings doctrine. Few in the legal community had known. Fewer had taken it seriously. When the Chief Justice raised his initial objection in court, publicly questioning whether Arnold understood the constitutional implications of his own position, it wasn't just a jab at his celebrity. It was a reinforcement of a narrative that had already taken shape behind closed doors, that Arnold's brief was polished but shallow, passionate but amateur. What the court didn't know, what very few people knew, was that the man standing at the lectern had spent nearly 7 years studying constitutional law, not as a vanity project, but as a disciplined pursuit conducted in private, away from cameras and campaign donors. After completing his term as governor of California, Arnold declined multiple offers to teach political science or public policy. Instead, he enrolled in a self-paced, supervised study program that allowed him to audit advanced legal seminars at UCLA. By day, he continued his public commitments, charity work, and occasional film appearances. But by night, in a quiet office in Brentwood, he read James Madison's letters, the Federalist Papers, and hundreds of pages of early American case law. Not because it was expected, but because it was necessary. He had seen firsthand how ambiguous property laws disproportionately harmed marginalized communities. Civil forfeiture, in particular, had become a tool of disruption, not justice. His decision to write the brief in Henderson wasn't spontaneous. It was a result of a 5-year research endeavor that included court visits, conversations with public defenders, and evenings spent combing through dusty volumes at the UCLA Law Library. He never announced it. He never published op-eds. And when he submitted the brief, he did so with no press release, no media agent, no promotional tweet. Just a dense, rigorously cited argument that questioned the legal foundations of modern forfeiture doctrine. Inside the Supreme Court that morning, none of this history was visible. Robert saw a suit, a famous face, and a challenge to long-settled law. But the room was beginning to shift. Justice Elena Kagan leaned slightly forward in her chair, eyes narrowing, not in skepticism, but in scrutiny. Justice Alito, arms crossed, tapped the pen silently against the bench. Even Justice Thomas, whose silence had spanned nearly the entire term, appeared alert. Arnold's opening remarks had not stumbled. More than that, they had avoided the two common pitfalls of amateur litigants: vagueness and verbosity. Every word he chose had weight. He had not rehearsed these remarks like lines from a film. He had built them layer by layer, over years. When he quoted the Fifth Amendment, he did so from memory. When he referenced Austin v. United States, it wasn't in passing, but with specific analysis. His notes, only a single page in length, sat untouched on the podium. Instead, what guided him was something more durable: the discipline of long-form study and clarity that only immersion could provide. In the second row of the gallery, a young law student from Howard University whispered to her professor, "He's not just holding ground, he's commanding it." The professor nodded slowly. "This is no celebrity stunt," he replied. "He's shifting the room." What Arnold had anticipated, and what few expected, was that Roberts would challenge him early, forcefully, and publicly. It wasn't just judicial custom being broken when the Chief Justice interrupted so quickly. It was strategy. Roberts had a reputation for exposing weaknesses through layered hypotheticals and obscure citations. His goal was often surgical: locate the weakest part in an argument and make it collapse under its own weight. But when he had referenced to Palmyra, Arnold hadn't blinked. When Roberts implied he misunderstood the reach of Bennis v. Michigan, Arnold had pointed to the exact page in his brief where he'd addressed it, drawing a nuanced distinction between maritime jurisdiction and land-based takings. He wasn't just defending his ideas. He was controlling the tempo. What surprised the justices wasn't his composure. It was his command. When Roberts tried to steer the debate toward practical implications, how overturning precedent might affect law enforcement, Arnold countered with Department of Justice data, extracted and analyzed from 10 years of forfeiture reports. When Justice Barrett later asked whether his brief connected due process with the takings clause in a new way, Arnold explained how James Madison viewed both protections as part of a single moral obligation between state and citizen. This wasn't the voice of an actor reading a script. It was the voice of a scholar who had outstudied everyone's expectations. And for the first time in that courtroom, eyes began to shift, not away from Arnold, but toward him, slowly, uneasily, respectfully. In a moment that would later go viral, Arnold paused to sip water. His hands didn't shake. A nearby mic caught the sound of Justice's pen dropping onto a notepad. Someone in the press box whispered, "This isn't going the way they thought." The courtroom that had once expected a spectacle was now holding its breath, not out of curiosity, but out of reverence. What remained to be seen was not whether Arnold would survive the hearing, but how far he would take the argument, and how many assumptions he would append before. Chief Justice Roberts leaned forward, his fingers steepled, voice sharper than before. "Mr. Schwarzenegger," he said, "your brief argues that the original understanding of civil forfeiture was limited to admiralty and customs law, but you seem to have overlooked a foundational case, the Palmyra decided in 1827. That ruling granted the government authority to seize property even in the absence of a criminal conviction. Do you dispute its relevance?" The tone carried more than inquiry. It was the kind of question that had undone seasoned litigators, baited them into contradiction, or exposed gaps in preparation. The courtroom stiffened. Law clerks sat straighter. Even journalists paused their typing. It was a move everyone expected. The moment the Chief Justice tested whether the celebrity brief could hold up under real fire. But Arnold didn't blink. He looked directly at the bench, nodded once, and replied evenly, "With respect, Chief Justice, I have not overlooked the Palmyra. In fact, I addressed it in detail, page 24 of my brief, third paragraph." He didn't reach for his notes. He didn't glance down. He simply waited. There was a moment's silence, and then, slowly, Roberts lifted the brief from his desk, flipped the pages, and found it exactly where Arnold said it would be. Arnold continued, "While the Palmyra did affirm the government's ability to seize property without first convicting an owner, the context matters. It was a maritime case involving a vessel suspected of piracy, a situation in which the court lacked personal jurisdiction over the offender. As Justice Story wrote, the vessel which commits the aggression is treated as the offender. That legal fiction was acceptable in admiralty law, where pursuing the individual actor was often impossible. But that rationale was never intended to govern domestic property seizures against American citizens residing within reach of the court's authority. A quiet murmur moved through the gallery. Justice Kagan leaned forward, her pen now actively scribbling. Justice Thomas remained still, but lifted his eyes. And in the gallery's back row, two appellate clerks exchanged glances. One mouthed the word accurate. Arnold hadn't just acknowledged the precedent. He had dissected it, reframed it, and placed it in historical context in under 60 seconds. Justice Alito broke in, his voice firm. Mr. Schwarzenegger, that's an interesting interpretation. But how do you address more modern cases? Bennis v. Michigan for example. In that case, we upheld the forfeiture of a vehicle from an owner who had no knowledge of any illegal activity. Would you have us overturn that ruling? Arnold nodded slightly, as if expecting the question. Justice Alito, he said, I believe Bennis was wrongly decided, and I'm not alone in that assessment. Justice Stevens dissented powerfully, joined in part by Justice Ginsburg. The issue in Bennis was a forfeiture of an innocent spouse's vehicle, used without her consent for illegal activity by someone else. The court upheld it under a doctrine that has since been deeply questioned. He paused, then reached for a second document. But since Bennis, this court has refined its understanding. In Austin v. United States, you held that civil forfeitures are subject to the Eighth Amendment's excessive fines clause. In Deems Petty, Indiana that principle was incorporated against the states. The logical trajectory is clear. Civil forfeiture is quasi-criminal in nature, and therefore must respect due process and proportionality. He looked around the chamber. I am not asking the court to abandon law enforcement tools. I am asking it to restore constitutional boundaries. Bennis expanded government power in a direction that both original intent and recent rulings suggest is unsustainable. The courtroom was quiet again, not frozen, but focused. Justice Barrett, who had until now remained still, made a note. Justice Sotomayor's gaze hadn't shifted from Arnold for several minutes. The tension that once surrounded the lectern had changed. It no longer asked, does he belong here? Now it whispered, how far is it going to take this? Chief Justice Roberts leaned back, his tone slightly more measured. Your brief also cites several obscure state court cases from the early 1800s, decisions rarely, if ever, discussed in modern constitutional scholarship. Why should we consider those persuasive? Arnold's reply came not with defensiveness, but precision, because they reflect the actual practice and understanding of the law during the founding era. Far from being outliers, they represent a pattern. In Commonwealth v. Franklin, 1806, Pennsylvania, the court held that property could not be seized without clear personal culpability. In State v. Rhodes, 1811, Virginia, a forfeiture was reversed because the owner was never charged. And in People v. Langston, 1815, New York, the court ruled that property rights included not just ownership, but use and benefit, requiring due process before deprivation. He paused, eyes fixed on the bench. I didn't find those cases in summaries or law reviews. I found them in physical archives, microfilm, handwritten decisions, marginalia. They aren't widely cited because they require effort to access. But that doesn't make them less authoritative. It only makes them forgotten. And sometimes, what's forgotten is exactly what needs to be remembered. There was a subtle shift in posture on the bench. The justices were no longer testing Arnold. They were listening. The spectators were no longer observers. They were witnesses. Justice Kagan spoke. Mr. Schwarzenegger, your historical research is unusually thorough. Did you conduct this work yourself? For the first time that morning, Arnold allowed a faint trace of pride into his voice. Yes, Justice. I consulted scholars, of course. But the archival work, the case tracing, the comparative analysis, I did that myself, over the course of 5 years. Not for this case, specifically, but for the principle it represents. The room was still. It wasn't the kind of stillness born of doubt or scrutiny. It was a stillness that comes when preconceptions collapse and something new takes their place. The moment the courtroom realized this was not a performance, this was the beginning of a reckoning. And Arnold Schwarzenegger, bodybuilder, actor, governor, was proving to be something no one had anticipated. A constitutional originalist, one with both the evidence and the voice to demand. As Arnold stood calmly at the lectern, having just dismantled a series of precedents with surgical precision, something unspoken rippled through the Supreme Court chamber. The shift wasn't announced. It didn't need to be. It lived in the subtle movements. The way Justice Sotomayor leaned in closer, how Justice Kavanaugh had stopped looking down at his notes and instead watched Arnold's face with full attention, and the fact that even Justice Thomas, who had said nothing for months, now rested his chin on one hand, fully engaged. The quiet murmur of doubt that had once circled the courtroom had evaporated, replaced by a deep, focused stillness. The kind of stillness reserved not for celebrities or politicians, but for scholars who say things that might actually change the law. Up at the bench, Chief Justice Roberts sat upright, his earlier tone of skepticism slowly giving way to something more measured. If he had hoped to catch Arnold off guard, the effort had failed, not because Arnold deflected the questions, but because he answered them more thoroughly than expected, as though anticipating them for years. The trap had been set, but the intended target had walked through it untouched. Justice Kavanaugh, who had remained silent until now, cleared his throat. "Mr. Schwarzenegger," he began, "your historical framework is compelling, I'll admit, but I want to ask you something practical. Civil forfeiture is a major tool in law enforcement operations. Are you suggesting the court eliminate it entirely?" Arnold shook his head. "No, Justice Kavanaugh. I'm not asking the court to abolish civil forfeiture. I'm asking it to restore its boundaries." He turned a page in his notes, though it was clear he didn't need to. The Constitution permits the government to seize property, yes, but only when three conditions are met. First, there must be a substantial connection between the property and a criminal act. Second, if the owner is available to the court's jurisdiction, the government must either secure a conviction or prove knowing consent by clear and convincing evidence. And third, the forfeiture must serve a specific public use, not simply general revenue collection. He paused. This is not theoretical. These principles are grounded in early American jurisprudence, and they remain aligned with this court's modern rulings in Austin and Timms. Kavanaugh tapped his pen once against the bench. "You're proposing a three-part test?" "Yes," Arnold replied, "rooted in history, consistent with doctrine, and respectful of individual rights." In the gallery, a CNN legal correspondent typed rapidly into her laptop. The man next to her, a former federal prosecutor, had his arms crossed, but his posture had softened. There was no more chuckling, no whispering about showmanship. Arnold had brought more than credibility. He had brought structure. And structure was what the court needed if it was to move away from decades of precedent without inviting chaos. Chief Justice Roberts glanced at the clock. Arnold's 10 minutes had expired 3 minutes ago, yet no one had interrupted him. The time extension, rarely granted and never acknowledged aloud, was a signal in itself. Court officers along the walls had stopped their usual quiet rotations. Even the press box remained still. Justice Elena Kagan, whose academic background often made her the court's most probing questioner, spoke next. "Mr. Schwarzenegger, your brief mentions an unpublished letter from Madison in which he references both due process and takings as interwoven principles. Can you elaborate on that?" Arnold's expression didn't change. He had been waiting for that question. "Yes, Justice Kagan. While preparing this argument, I spent several evenings at the Library of Congress reviewing the Madison papers, specifically his correspondence from 1788. In one letter to Jefferson, he writes that the arbitrary seizure of lands, without process or compensation, is a double violence upon the right most sacred in ordered society. That phrasing, double violence, reveals how Madison saw due process and just compensation not as separate protections, but as one unified safeguard. The state, he believed, must be held to both. He opened a folder and produced a photocopy, faint handwriting preserved in pale ink. This letter hasn't been cited in any forfeiture case to my knowledge, but its language is unmistakable. The founding generation did not view property merely as land. They saw it as liberty made tangible. Justice Barrett spoke for the first time. That's a bold statement, Mr. Schwarzenegger. Are you arguing that modern forfeiture violates the philosophical foundations of property rights? Yes, he answered, simply. When the government takes from innocent citizens without proving guilt or necessity, it not only breaches the Constitution, it erodes trust. And without trust, law is force, not justice. A beat passed, then two, and for the first time in nearly an hour, the chamber exhaled. Chief Justice Roberts adjusted his posture, no longer leaning to challenge but to understand. Mr. Schwarzenegger, he said, his voice notably softer. You've referenced several state court rulings, an obscure Madison letter, and multiple 19th century cases. That's more primary source material than most amicus filings in the past 5 years combined. Did you work with a research team? Arnold shook his head. No, Chief Justice. I had support from a few legal mentors. But the research, reading old records, transcribing, cross-referencing, was my own. I didn't want a team. I wanted clarity. And sometimes, clarity comes from wrestling with the material yourself. No one in the room smiled, not because they weren't impressed, but because what was unfolding no longer felt like performance. It felt like a shift, the kind that doesn't happen often, especially not in a courtroom designed to resist change. Arnold had entered the building as a curiosity. He now stood as a force, not because of who he had been, but because of what he had brought. A map back to the beginning, and a challenge no one on the bench could dismiss without reckoning with the history he had unearthed. The next question would come soon enough, but in that moment, there was only silence, the kind that follows not confusion. But the transformation inside the Supreme Court chamber wasn't loud, but it was undeniable. The justices no longer regarded Arnold Schwarzenegger as an unexpected presence to be tolerated. He was now an argument to be reckoned with. The air had shifted from distant curiosity to deep intellectual engagement. Even the court reporters, trained to be expressionless observers, now moved their pens with urgency, sensing that something far beyond routine litigation was unfolding. And it was in that heightened silence that Arnold made his next move, not through volume, but through history. He reached into his briefcase and carefully removed a manila folder worn at the edges. From it, he pulled a single photocopied document. Aged handwriting, faint and slanted, barely legible without close attention. The room watched as he laid it gently on the lectern. This, he said evenly, is a letter written by James Madison in 1788. It was addressed to Thomas Jefferson and remained unpublished in mainstream legal literature until very recently. I located it while studying at the Library of Congress, deep within the Madison Papers archive. He waited a beat, then continued. In this letter, Madison warns against what he calls a double violence, his phrase, not mine. He writes, when a citizen's property is seized without a finding of guilt and without any public use, the state commits a double violence, against liberty and against justice. Arnold let the words hang. The phrase landed with force, not because it was dramatic, but because it was undeniable. No one had quoted it before, not in Venice, not in Austin, not in Thames. And yet here it was, spoken aloud for the first time in open court, a forgotten warning from one of the Constitution's authors, unearthed by a man no one had expected to find it. Justice Kagan leaned forward, her tone more curious than skeptical. Mr. Schwarzenegger, to your knowledge, has this letter ever been cited in federal court? No, Justice, Arnold replied. To my knowledge, it hasn't even been digitized in the primary legal databases. I found it through handwritten index cards in the microfilm archive. It took 3 evenings to verify its authorship and confirm it wasn't a duplicate of other known letters. But what struck me most wasn't its obscurity. It was how clearly it reinforces the constitutional boundaries we are here to discuss. Justice Barrett spoke next, quieter but firm. And you're suggesting this should carry weight in the court's analysis today? I am, Justice, Arnold said without hesitation. Because if we agree that constitutional interpretation begins with original understanding, then this letter, authored in the same year the Constitution was ratified, offers unfiltered access to the founder's intent. Madison saw property not merely as land or wealth, but as a physical embodiment of liberty. When the government violates that without guilt or purpose, it breaks faith with the very structure of our law. The room remained still, not from doubt, but from recognition. Every person present understood the magnitude of what had just occurred. A letter from a founder, buried in history, now placed on a record, not by a law professor, not by a justice, but by a man who had once been defined by muscles and movies, now reshaping legal dialogue with archival evidence. Chief Justice Roberts, who had been silent for several minutes, finally spoke. His voice no longer carried the edge it had earlier that morning. Mr. Schwarzenegger, you argue that this letter confirms a philosophical view that takings and due process are not separate concepts, but a single constitutional safeguard. But wouldn't that require this court to reframe a century's worth of jurisprudence? Arnold nodded. Yes, Chief Justice, it would. But jurisprudence evolves not when it is convenient, but when it is necessary. The court has already taken steps in Austin and Thames. What I'm suggesting is not revolution, but correction, anchored in history, informed by principle, and executed through doctrine. Roberts tilted his head slightly, then glanced at the document once more. He didn't challenge its validity. He didn't dismiss its relevance. He simply absorbed it. Arnold continued, "The reason this letter matters is not because I found it. It matters because it exposes the moral weight of property protections, weight that has been obscured by decades of procedural shortcuts. If the government can seize a church, a home, a community center without charging anyone, then it has stepped beyond its role as a servant of the people and become something else entirely." He looked directly at the bench. This isn't about theory. It's about restraint. About making sure the state never grows so confident in its power that it forgets who it serves. Justice Sotomayor nodded once, not as an endorsement, but as acknowledgement. It was clear now that Arnold's presence was not an anomaly. It was a recalibration. In the gallery, someone's phone buzzed, a silent alert from a news outlet already reporting on the letter. Legal bloggers were posting screenshots. Law professors were already speculating how it would be cited in future cases. And yet, Arnold remained still, composed, focused only on the bench before him. The weight of his research, his discipline, his presence. It had all built to this moment, not to impress, but to clarify. And as the court recessed for lunch, no one said much. There were no jokes, no smirks, only the quiet shuffle of papers and the low murmur of legal minds reshuffling their priors. Outside the chamber, a law clerk for one of the justices turned to her colleague and whispered, "He didn't just cite Madison, he brought him back into the room." And somewhere in the hallway, a reporter finished typing the headline that would go viral before sunset. Asterisk Schwarzenegger stuns court with lost Madison letter. Forces a constitutional reckoning. When the court reconvened that afternoon, there was a noticeable change in atmosphere. The usual stiffness of protocol had softened, not into informality, but into something more engaged. The bench was no longer treating Arnold Schwarzenegger as a guest speaker. He was now a co-architect of the moment, helping to draft the contours of a legal turning point. For a man who had spent much of his life in front of cameras, the silence in this courtroom spoke louder than any standing ovation. Chief Justice Roberts, his tone now entirely professional, returned to the central issue. "Mr. Schwarzenegger," he said, "your historical argument is compelling, but this court must also consider the real-world implications. If we adopt your view, what specific test would you have us apply to determine whether a civil forfeiture is constitutionally valid?" There was no pause, no hesitation. Arnold had anticipated the question from the very beginning. He nodded once and raised 3 fingers. "Chief Justice, I respectfully propose a 3-part test. One that honors original understanding, aligns with your court's evolving jurisprudence, and provides clarity for future enforcement." He lowered his hand and began. "First, the government must establish a substantial and direct connection between the property and a criminal act. Mere proximity or association is not enough. If someone commits a crime on a public sidewalk, that does not make the adjacent building complicit." He allowed the thought to land before continuing. "Second, If the property owner is subject to the jurisdiction of the court, the government must either secure a criminal conviction or prove, by clear and convincing evidence, that the owner had actual knowledge of and consented to the illegal use of the property. This standard respects due process and distinguishes bad actors from innocent citizens. A few justices nodded, not in agreement, but in recognition. The clarity of a framework was undeniable. Justice Barrett picked up her pen again. Arnold lifted the final point. Third, the forfeiture must satisfy the public use requirement of the Fifth Amendment. That means the property must be used to remedy a specific harm, such as environmental contamination, fraud recovery, or public safety, not simply absorbed into general revenue. If a seizure exists only to generate money, it fails the constitutional test. He paused again, not to dramatize, but to breathe. This approach does not dismantle civil forfeiture. It restores its moral and legal legitimacy. It separates necessity from abuse. And it gives both the government and the citizen clear lines to follow. Roberts nodded slowly, looking down at the page before him. There was no immediate response. Instead, there was quiet calculation, the kind that happens when a judge begins to see a path through the thicket. Justice Sotomayor leaned forward. Mr. Schwarzenegger, are you suggesting this court should apply this test retroactively to existing forfeiture cases? Arnold shook his head. No, Justice. I believe this framework should govern cases moving forward. However, where existing forfeitures clearly violate these principles, particularly where no charges were filed and the owners were never heard, there may be constitutional grounds for relief. But that decision, respectfully, would be best left to the lower courts on a case-by-case basis. Justice Kavanaugh followed. Do you have data to support how this test would affect current practice? Arnold reached into his folder once more and removed a stapled sheet of printed tables. Yes, Justice. I obtained 10 years of civil asset forfeiture reports from the Department of Justice. I analyzed over 3,000 cases. Based on this model, approximately 87% of current forfeitures would remain unaffected. They involve customs violations, unclaimed contraband, or properties directly linked to criminal enterprises. He turned the page. The remaining 13% involve seizures like the one in Henderson, where no charges were filed, no direct connection was proven, and no public use was specified. These are the cases most likely to fall outside the Constitution's protection. Justice Alito raised an eyebrow. So you're saying that by adopting your framework, we retain enforcement efficiency while restoring constitutional discipline? Yes, Justice. And perhaps more importantly, we reaffirm that the rule of law is not a matter of convenience, but of structure. A tool that drifts from its constitutional boundaries becomes a threat, not a safeguard. For a moment, the courtroom felt like a classroom, one where the subject wasn't property or forfeiture or even history. It was clarity earned not by title or tradition, but by discipline and preparation. In the gallery, a political journalist who had expected a morning of recycled rhetoric sat stunned, her notepad filled with phrases she hadn't anticipated writing. 3-part test, double violence, public use, the story she had come to cover no longer existed. This was no longer about a celebrity stepping into legal waters. This was about a man redrawing the current. At the bench, Chief Justice Roberts folded his hands. Mr. Schwarzenegger, do you believe your test strikes the proper balance between individual rights and the government's interest in law enforcement? Arnold answered without raising his voice. I do, Chief Justice, because this isn't about making forfeiture impossible. It's about making it honest. The government should be able to seize property when the law justifies it. But the Constitution demands we never forget who owns the burden of proof and why. He closed the folder slowly and placed his hands on either side of the lectern. He didn't smile. He didn't need to. What he had offered wasn't persuasion. It was structure, a blueprint for recalibrating a system that had wandered from its foundation. And from the back of the chamber, as the echoes of his words settled into silence, someone whispered a sentence that would soon be quoted across legal blogs and editorial pages. He didn't just bring a test. He brought a way back to the Constitution. As Arnold stepped away from the lectern, the courtroom remained silent, an unusual stillness, as if no one dared to speak for fear of breaking the spell. Typically, Oral arguments ended with the Chief Justice briskly announcing that the advocate's time had expired. But this time, there was no interruption, no gavel tap, only the low hum of a shifting judiciary, processing what had just been laid before them. For nearly an hour, Arnold Schwarzenegger had stood before the highest court in the country and built a constitutional argument so grounded, so historically precise, and so morally urgent that it refused to be dismissed as novelty. He returned to his seat without fanfare. There were no cheers, no nods of approval, just the kind of quiet that accompanies respect, the kind earned, not given. Moments later, the government's attorney approached the podium. He shuffled his notes twice before speaking, his voice tight, eyes glancing quickly at the bench, then toward Arnold, then back again. The contrast was sharp. Where Arnold had stood still and spoke without aid, this man now seemed tethered to his brief, seeking refuge in printed lines that suddenly felt inadequate. His arguments focused on precedent, on enforcement burdens, on historical trends supporting civil forfeiture as a necessary tool. But the justices, while polite, were no longer interested in generalities. Their questions shifted tone. They asked about specifics, about intent, about original meaning. Over the next 20 minutes, it became clear that Arnold hadn't just offered a compelling position. He had reframed the lens through which the court would now examine the case. The burden had shifted. The government, once presumed right by inertia, now had to prove why its power should remain unchecked. Outside the chamber, word was already spreading. Legal blogs posted headlines mid-hearing. Schwarzenegger rewrites forfeiture debate. Former governor delivers originalist masterclass. And on law school group chats, screenshots of Madison's letter were circulating with captions like, "Did you see this? And is this real?" By the time the court adjourned, a dozen major media outlets had already drafted breaking alerts. But the most profound response wasn't happening on the news. It was happening in classrooms, in legal offices, and in the minds of those who had believed, perhaps unconsciously, that constitutional brilliance must always come in a specific package, with a specific resume, from a specific school. Arnold had broken that assumption, not with swagger, but with scholarship. 6 weeks later, the Supreme Court released its decision in Henderson v. Department of Justice. The vote was 7-2. The majority opinion, authored by Chief Justice Roberts himself, adopted a framework closely mirroring the test Arnold had presented. It cited the Madison letter. It referenced the historical cases he had unearthed. It quoted his phrasing directly, including the term double violence, and acknowledged the role of amicus counsel in restoring lost constitutional meaning. Justice Thomas wrote a concurring opinion that went even further, calling for a broader re-examination of modern forfeiture doctrine. Justice Sotomayor emphasized the disproportionate effect of these laws on marginalized communities, citing Arnold's data from the DOJ reports. And in a single footnote, brief but unmistakable, Roberts included a line that would be quoted for years. This court is grateful for the extraordinary preparation, historical insight, and principled advocacy offered by counsel for amicus curiae. The legal world reacted immediately. Within days, state legislatures began reviewing their own forfeiture laws. Within weeks, legal scholars were publishing responses and analysis. And within 2 months, 3 separate law schools invited Arnold to guest lecture on the history of property rights. He accepted each invitation with little public comment. But something deeper had shifted. He was no longer a celebrity who had wandered into legal territory. He was now part of that territory's living story. In an appearance at a public legal forum at Georgetown, Chief Justice Roberts and Arnold sat side by side on a panel titled Liberty and the Law, re-examining the Fifth Amendment. During the discussion, Roberts addressed a moment in court when he had first questioned Arnold's understanding of constitutional law. "I was wrong," he said simply. "I confused background with capacity. I underestimated preparation. That mistake won't happen again." The room fell silent, not out of shock, but out of rare judicial humility. When Arnold responded, he did so not with vindication, but grace. "The beauty of the law," he said, "is that it doesn't care where you came from. It only asks if your argument holds." His words traveled far beyond the walls of that forum. In classrooms across the country, professors added the Henderson decision to their syllabi. Legal podcasts dissected every moment of the oral argument. And in one particularly moving video shared millions of times online, a law student at Howard University said, "He didn't just win the argument, he made space for the rest of us to speak." Later that year, Arnold launched the Schwarzenegger Justice Initiative, a nonprofit focused on constitutional education and legal access in underserved communities. It wasn't a publicity move. There was no red carpet, no entourage, just a mission born from the belief that the law must serve everyone equally, and that sometimes the loudest change begins with the quietest preparation. The final irony, of course, was never lost on the public. The man once known for one-liners and action scenes had reshaped one of the most complex areas of American law, not with force, not with fame, but with footnotes, founding documents, and unshakable resolve. In the end, it wasn't his past that carried the day. It was his preparation, his discipline, and the courage to walk into the most powerful courtroom in the country, not to perform, but to persuade. And that, more than any film or headline, became his most enduring